So we've had some filings in the Chile case, and they're very interesting filings. This is Chile against Google, Abrams, and Masshole. And let's have a look and see what's happening. We've got the judge posting items number 131, 132, 133, 134, and 135. So first, 131, which is the memorandum and order concerning the second motion of contempt, which was Jose's second motion. Let's just look at this. So, before the court is plaintiff Jose de Castro's second motion for contempt, in which he asked that this court hold defendant Catherine Peter in contempt of court. For the reasons stated below, plaintiff's motion is denied. I won't go through the background. I'm just gonna, you can stop and pause the screen if you want to. Let's have a look at the analysis. A district court may issue a civil contempt order if the moving party establishes by clear and convincing evidence that 1. The alleged contemptor had notice of the order, 2. The order was clear and unambiguous, 3. The alleged contemptor had the ability to comply with the order, and 4. The alleged contemptor violated the order, and there's some references there. Peter concedes that she had notice of the court orders and does not dispute that she had the ability to comply with them. Instead, Peters argues that she did not violate the orders and they are not clear and unambiguous. Peter also avers that De Castro does not allege with any amount of specificity how any of her actions amount to threatening, harassing, illegal or otherwise inappropriate behaviour that occurred when engaging with each other. The parties did not agree to a moratorium on speaking about one another on the internet, and the court declined to place a prior restraint on the parties' speech. Thus, the fact that Peter spoke about De Castro on the internet, even if it was in a disparaging manner, does not itself violate the court's order. The court also explained, however, that any videos made by the parties could not cross the line into defamation or harassment, because defamation has legal consequences and harassment will be in violation of the court order. Though the court has repeatedly recommended that the parties refrain from hostile behaviour, and does so again here, it finds the calling De Castro a liar and inviting others to comment on his publicly available website without more detail does not constitute harassment or defamation. Moreover, trade disparagement is neither harassment nor defamation. Thus, the court finds Peter did not violate the court's order and De Castro's motion is denied. So that's the first one we've got. Right, now on to the second one, which is a 132, and this is judge's memorandum order on plaintiff's motion for disclosure, and it's denied. Let's have a look at the actual memorandum and order. So before the court, plaintiff Jose De Castro's motion for disclosure of ex parte communications received by the court, 2. Disclosure of information regarding any personal bias or prejudice the court has against plaintiff, and 3. Answers from the court to 2 questions posed by plaintiff. Defendants did not file a response. For the reasons stated below, plaintiff's motion is denied. First, plaintiffs asked for disclosure of any ex parte communication concerning this action. As support, plaintiff identifies the Code of Conduct for U.S. Judges canon, which provides, if in relevant part, 1. If a judge receives an unauthorised ex parte communication hearing on the substance of a matter, the judge should promptly notify the parties of the subject matter of the communication and allow the parties an opportunity to respond, if requested. Plaintiff also references the court's previous order in this action, providing that a. Any communication received from a party to this litigation will be placed on the public record. The court has notified and will notify the parties of unauthorised ex parte communication, bearing on the substance of a matter, and or will file on the docket any ex parte communications received from a party to this litigation. To the extent plaintiff requests additional and broader disclosure, plaintiff's request is denied. Second, plaintiff requests disclosure of information regarding any personal bias or prejudice the court has against plaintiff that may give rise to a reasonable question about the court's impartiality. There is no information to disclose in this regard, and plaintiff's request is therefore denied. Third, plaintiff requests that the court answer the following questions. 1. Is Judge Burrows a member of any law enforcement police associations, including any and all contribution and awards? 2. What does Judge Burrows know about plaintiff in addition to the record for this action? The court is in full compliance with all applicable ethical obligations and has no obligation to respond beyond that. The court nonetheless notes that it has no information to disclose in this regard that bears on the substance of this matter or the court's impartiality. Thus, plaintiff's third request is denied. Accordingly, plaintiff's motion is denied. So ordered. Right, let's have a look at the next one, which is 133. And this is memorandum and order regarding defendant's motions to dismiss. And these are granted. And Google's motion to transfer is denied as moot with leave to renew if necessary. So ordered. And let's have a look at the order. So here we have the memorandum and order. Plaintiff Jose Maria de Castro's plaintiffs filed suit against Joshua Abrams, F.UK.T, Google LLC, unknown John Doe defendants who publish on YouTube, and unknown John Doe defendants working on behalf of Google, collectively defendants claiming copyright infringement. Before the court are Abrams and Peters' motions to dismiss and Google's motion to transfer or the alternative to dismiss. For the following reasons, defendants' motions to dismiss are granted and Google's motion to transfer is denied as moot with leave to renew if necessary. We'll skip through the background.
Sorry, I didn't understand.
We'll skip through the background. 2. Legal standard. On a motion to dismiss for failure to state a claim pursuant to Federal Rule of Civil Procedure 12b-6, the court must accept as true and well-pled facts, analyse those facts in the light most favourable to the plaintiff, and draw all reasonable inferences from those facts in favour of the plaintiff. There's a reference. Additionally, a court may not look beyond the facts alleged in the complaint, documents incorporated by reference therein, and facts susceptible to judicial notice. Again, a reference. A complaint must provide a short and plain statement of the claim, showing that the pleader is entitled to relief. Again, another reference. And must set forth factual allegations, either direct or inferential, respecting each material element necessary to sustain recovery under some actionable legal theory. Another reference. Although detailed factual allegations are not required, a complainant must set forth more than labels and conclusions. Another reference. And threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. Again, another reference. Rather, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. 3. Analysis. To establish copyright infringement, a plaintiff must prove two elements. 1. Ownership of a valid copyright, and 2. Copying of constituent elements of the work that are original. References. First, to show ownership of a true copyright, a plaintiff must prove that the work as a whole is original and that the plaintiff complied with the applicable statutory formalities. Another reference. With regard to statutory formalities, 17 U.S.C. 411A or 411A provides that a party bringing a federal copyright infringement suit must show that the party had either registered its copyright with the U.S. Copyright Office or that the U.S. Copyright Office had refused to register the copyright after the party had delivered the proper deposit application and fee to that office. 17 U.S.C. 411 (A). No civil action for infringement of the copyright in any United States work shall be instituted until pre-registration or registration of the copyright claim has been made in accordance with this title. And then there's a reference. The copyright registration requirement set forth in 411(a) is a precondition to federal copyright infringement suits. Second, to show that a defendant copied constituent elements of the work that are original, a plaintiff must show that 1. The defendant actually copied the work as a factual matter, and 2. The defendant's copying of the copyrighted material was so extensive that it rendered the infringement and copyrighted works substantially similar. And there's a reference. Defendant's impertinent part moved to dismiss because 1. Plaintiff has failed to show that he has met the copyright registration requirements to file suit. 2. Plaintiff has not identified any allegedly infringing material from defendants. 3. Plaintiff's claims are barred by the fair use doctrine. As to registration, plaintiff argues that he need only allege ownership of the copyrighted materials, which he has done, and that in any event he hereby declares in response to the motion that he has successfully and completely registered at least one key video in his complaint, and that the registration can easily be found by searching the public catalogue at loc.gov. With regard to infringement, plaintiff argues that the materials infringed by defendants can be further clarified through the discovery process, and that the fact that the defendants have not requested a more definitive statement, but rather asked that this court decide fair use, makes it clear that the complaint was sufficient to give notice. The court agrees that plaintiff has failed to plead sufficient facts to support a finding that he has met the copyright registration requirement, which is a prerequisite to bring in suit. In the complaints, plaintiff pleads, without record support, that he is the owner of the valid copyright for the videos that he publishes. This is insufficient to support an inference that he has complied with the registration requirements of 411(a). And there's some references. The copyright registration requirement set forth in 411(a) is a precondition to federal copyright infringement suits. Another reference. Finding a plaintiff's statements that his work was fixed and copyrighted under the Copyright Act of 1976, USCA 203A, insufficient to plead a valid registration. Plaintiff's claim in his response to Google's motion that he has registered at least one key video in his complaint does not remedy the deficient pleading. Plaintiff must have 1. Obtained his registration prior to instituting this action, which appears he did not, and 2. Sufficiently alleged in the complaints that did so. Sufficiently alleged in the complaints that he did so, which he did not. Reference. And affirming dismissal where plaintiff failed to allege that registration had been obtained prior to suit, despite finding there was no dispute that the Copyright Office registered plaintiff's work after he filed his complaint. And another reference. On remand, denying motion to amend complaint because copyright was not registered prior to the filing of the original complaint. Thus, as plaintiff has failed to allege that he complied with the copyright registration requirements prior to filing suit, the court dismisses the complaints against all defendants. Because the court finds that the complaints should be dismissed for failure to comply with applicable statutory formalities of 411, it need not decide whether plaintiff adequately pled a claim for copyright infringement. In any event, the court notes that plaintiff's complaints do little more than generally allege that defendants copied his videos. For example, plaintiff does not cite, identify, or describe a single instance of the alleged copying that would allow the court to infer that defendants' copying of the material was so extensive that it rendered the infringing and copyrighted works substantially similar. That's reference. The mere allegation that a defendant copied the work of a plaintiff is insufficient on its own to establish a claim for copyright infringement. Another reference. Copying does not invariably constitute copyright infringement. Conclusion. Accordingly, defendants' motion to dismiss are granted and Google's motion to transfer is denied as moot with leave to renew if necessary. So that's 133. So the main action is dismissed. Let's go on to 134. And this is a memorandum and order. De Castro's motions to dismiss Abrams and Peters' counterclaims are granted. So ordered. Let's have a look at the actual memorandum and order. After plaintiff Jose Maria de Castro filed a complaint against Joshua Abrams and Kate Peter, asserting claims for defamation and intentional infliction of emotional distress, Abrams and Peters answered the complaint and filed counterclaims for defamation. Before the court are De Castro's motions to dismiss Abrams and Peters' counterclaims. For the reasons stated below, De Castro's motions to dismiss are granted. Skip through the background. Right, procedural history. On September 2nd, 2022, De Castro filed suit against Abrams and Peter for defamation and intentional infliction of emotional distress. And on November 7, 2022, Abrams and Peter answered the complaint and filed counterclaims for defamation. De Castro moved to dismiss the counterclaims on December 8, 2022 and December 11, 2022. De Castro also filed supplemental authorities in support of his motion to dismiss Abrams' counterclaims on December 12, 2022. Abrams opposed on December 21, 2022, and Peter opposed on December 27, 2022. Discussion. De Castro moves to dismiss both counterclaim complaints on 4 grounds. 1. Lack of subject matter jurisdiction under Federal Rule of Civil Procedure 12b-1. 2. Lack of personal jurisdiction under Rule 12b-2. 3. Insufficient process under Rule 12b-4. And 4. Failure to state a claim under Rule 12b-6. Because the court finds that Abrams and Peter have not sufficiently pled facts to support subject matter jurisdiction, the court only reaches the first issue. Federal district courts have original diversity jurisdiction over all civil actions in which the parties are citizens of different states, and the amount in controversy exceeds $75,000. There's a reference. With respect to the amount in controversy, the sum claimed by the plaintiff controls if the claim is apparently made in good faith, and it must appear to a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal. Again, another reference. Normally, a plaintiff's general allegation that the dispute exceeds the jurisdictional minimum is sufficient to support jurisdiction, but when challenged, the plaintiff has the burden of alleging with sufficient particularity facts, indicating that it is not legal certainty that the claim involves less than the jurisdictional amount. Again, another reference. For example, in Anderson, the plaintiff alleged that her claims exceeded the statutory amount in controversy requirement, and she demanded $7,186,785 in damages. Her complaint also claimed that she gave away free services on at least 30 occasions and asserted hundreds of cancelled monthly memberships, the loss of over 8,000 clients and 2 employees, and lost profits. Defendant moved to dismiss under Rule 12b-1 based on plaintiff's failure to sufficiently establish that her claims met the amount in controversy requirement. In response, instead of proffering additional factual support, plaintiff simply relied on the face of her complaint. The First Circuit first found that because the defendant contested the sufficiency of the pleading, the burden shifted back to plaintiff to present with sufficient particularity facts that in some way support the contention that there is more than $75,000 at stake, and a reference. The plaintiff did not meet the pleading requirement in part because she attached no monetary value to services given away or to monthly membership clients and employees lost. Further, while plaintiff claimed lost profits, she proffered nothing as to the profits or overall value other than calling her company successful. Here, De Castro challenges whether the amounts claimed by Abrams and Peter exceed $75,000. As explained in Anderson, this shifts the burden to Abrams and Peter to show with sufficient particularity that it is not a legal certainty that the claim involves less than $75,000. Like the plaintiff in Anderson, they have failed to do so. Abrams pleads that the amount in controversy exceeds $75,000 because De Castro's actions have reduced the membership and viewership of Abrams' YouTube channels, which in turn reduced the revenue earned from his videos. Abrams does not provide any specific calculation or estimate of monetary damages resulting from De Castro's conduct. For example, he provides no information about how many individuals view and or are members of his channel, how much revenue he gets from members and or viewers, or how many members and or viewers he lost because of De Castro's statements. With respect to Peter, she does not even bother to state that the amount in controversy exceeds $75,000, and only generally alleges that De Castro's actions caused her damage. She does not explain how she has been damaged, and if she has been damaged monetarily, how and by how much. Thus, the court finds that neither Abrams nor Peter have established with sufficient particularity that it is not a legal certainty that the claim involves less than $75,000. Because Abrams and Peter have failed to plead sufficient facts to establish that the court has subject matter jurisdiction, the claims must be dismissed under Rule 12b(1). 3. Conclusion. Accordingly, De Castro's motion to dismiss Abrams and Peter's counterclaims are granted. So ordered. So that's document 134. And we now need to go to document 135, which is the order dismissing the case. It's a very simple document. Jose Maria De Castro v. Joshua Abrams et al. Order of dismissal, Burroughs DJ, in accordance with the court's memoranda and orders dated July 11, 2023, it is hereby ordered that the above entitled action be and hereby is dismissed. As I record this, and I'm going to go and look to see if I've got it clarified, I'm not sure if this means it's been dismissed without prejudice. I just need to clarify that. Thanks for watching.